Hello and welcome to Season 4, Episode 2 of our Frenemies series. As you know from prior episodes, we're focusing this Frenemies series on legal issues that come up in the field of marketing and areas where marketing plans need to align with legal plans. In case you missed the first episode of this season, we're focused all in this season about acronyms that you're probably going to hear whenever you speak to an attorney about marketing practices. In this episode specifically, we're going to talk about spam. And when I mention spam, I don't mean the food. I mean, we're talking about email spam, messages that are delivered and not wanted, and a law that was passed many years ago governing email communications. So I'll start off the presentation talking about email, and then I will shift to my colleagues, Sarah and Amy, who will be speaking with you more on the second half about text messages and phone calls. We know that as marketing professionals, it's your job to get out in front of customers. That might be past customers, current customers, or future customers, and getting in front of them as much as possible to sell your product. Some ways you might do that would be email, text messages, phone calls, and each method of those communications triggers its own set of legal obligations that you should keep in mind. So we're going to explore two laws in particular today, the Consent Act and TCPA. I'll start by introducing just generally, what does Consent Act even mean? One of these crazy acronyms. Well, it stands for Controlling the Assault of Non-Solicited Pornography and Marketing Act of 2003. So you'll see this was an old law passed in 2003. I consider it old these days, but even in those early 2000s, Congress could see that commercial messages were becoming more prominent as a way to communicate with consumers, and consumers likely needed more control over the types of messages that they receive and how to avoid receiving messages in the future. So even in the early days of the internet, it was very apparent that there needed to be some kind of law passed, and the growing use of email spurred this law to be passed. So it clearly covers email messages. That's very clear in the statute that that is within the scope. There are some court decisions that suggest private messages that function similarly to a commercial email message could be within the scope. So think about your social media platforms where there's a inbox, you sending a message to a unique recipient, potential that it could be covered by the Consent Act as well. Generally speaking, email seems to be the predominant factor of focus when talking about CAN-SPAM. The law is enforced by federal regulators. So that would be an entity called the Federal Trade Commission, who is got jurisdiction throughout the country, but also state attorney generals can have ability to bring in enforcement action under the Consent Act. So could be two levels of government involved. And each separate email violation that's in violation of the law is subject to a penalty under the statute of $43,000. So that could add up very quickly when you think about how many consumers you're emailing and how often you're emailing. And so to avoid the regulatory fines, it's important to keep in mind what the Consent Act requires. So I'm assuming if you're watching this, you likely send email messages to your customer base in some capacity. And it could be a commercial message or a transactional message. And there's a clear distinction in the statute of what each of those messages are, but you could probably guess based on their name, the nature of those two types of messages. A commercial message is one where you're advertising or promoting a commercial product or service. So that's a commercial, meaning you are advertising, and that's the simple way to think of it. A transactional message, on the other hand, is where you already have a business relationship in place. Maybe someone's placed an order. You need to email them to tell them about the status of their order or to confirm that you received the order. That's a pure transactional message. So those are the two sides of the spectrum, but obviously you're going to have messages that are somewhere in between those two extremes. Those are characterized as mixed messages. An example might be you send a message to Jane Smith. The subject line is your account statement, and the body of the message talks all about how Jane Smith has a payment coming due and all the details about completing that payment. And the very bottom of the email, towards the footer, you might say something like, visit our website for more exciting news about our new products, period. and that's the end of the email. Well, you'll see in that example, you have two different types of communication. You have the pure transactional, where you're telling someone about an ongoing transaction and needing to communicate for that purpose. But you did have some commercial element to it by having that sentence at the bottom talking about new products. So in that situation, when you're assessing whether or not you fall into the commercial versus transactional camp, you want to think about different factors that sway what's the primary purpose of the communication. In the example I just gave you, the subject line had a purely transactional message, your account statement. The beginning of the message was all about that transactional purpose. And the overall percentage of the commercial to transactional ratio is pretty small. It was pretty insignificant, just one sentence at the bottom talking about new products. So those factors would all sway into making the determination that it was a transactional message versus a commercial message. Other factors that didn't come up in that example that you might want to think about is, how does the message look? You look at the graphics, the font style, the color, what's drawing the consumer's attention? Is there a little element of transactional, but the predominant focus is the commercial aspect of it because of how you stylized it? In that case, you might tip towards being a commercial message. We draw the distinction between a commercial and transactional message because the requirements would be different depending on what type of message you send out. If it's a transactional message, you have a much fewer requirements under the Consent Act. You would need to make sure you have an accurate header and an accurate subject line, the first two requirements that you see on the slide. If you have a commercial message, however, you would need to have all 5 requirements met that are on the slide. So that's why we focus very intently on what's the nature of the message that you're receiving. Just to quickly go through the requirements, when I mentioned an accurate header and how it applies to all messages, so that would be the from field and the to field, making sure that you've accurately identified and clearly identified the business that initiated the message. An accurate subject line means you're not including anything that would be considered deceptive in the subject line. So you can't hide the fact that something's an advertisement by including a subject line that's all about transactional communication, or a type of bait and switch, kind of where you entice the customer to open the email and then the email had nothing to do with the subject line. Those two things are prohibited by any message that you send out to a customer. Now, if you have a commercial message, you need to go a step further. The third requirement for commercial messages are to identify that the message actually is an ad. There's no bright line rule on how you do this. There's a lot of customization allowed and leeway under the law, but it needs to be something that's very clear and conspicuous so the person who receives the email can quickly tell that it is communication in the nature of advertising. So you can work with your legal counsel to work through the mechanics, because it will depend on your company and maybe even the type of message you're sending, but that is something to keep in mind as you're working to put together a communication. The fourth requirement is to tell senders where you're located. So you have to include a mailing address in the email. It could be a street address, a PO box that's registered with the U.S. Postal Service, but some official mailing address of where you're located needs to be included in the email. And finally, and probably the most important requirement for commercial messages is to have an opt-out mechanism in place. In privacy law, you'll hear a lot about opt-out and opt-in. And whereas CAN-SPAM is opt-out, as you'll hear in a few minutes, TCPA is opt-in. And this means the default rule is different. So in email communication, you can email someone until they tell you, don't email me anymore. So that's what we mean by opt-out, is that you're giving someone the ability to take me off the list. So in the words of Chandler, tell him to email me at www.notsomuch.com. If you get one of those communications from a consumer, a key requirement of the CAN-SPAM Act is to actually honor those requests. We want to explore that a little bit more, because that's probably the most visible way that The end consumer could see whether or not you're following CAN-SAM Act, and the end consumer could always turn around and report you to a regulator, or your competitor could see that whether or not you're actually following opt-out. So this is probably the most visible way that it's easy to tell if a company is in compliance. Opt-outs have, under the statute, have specific requirements in place. So you probably are familiar with opt-out mechanisms, actually, because you, as a consumer, have received the emails yourself. And if you scroll to the bottom, there's a clear unsubscribe link where if you click the hyperlink, it takes you to a URL form, and you can check boxes to say, do not send me any more emails, or do not send me marketing emails. And you may have done that before when you received a message from a recipient that you didn't want to receive emails from anymore. That's all because of CAN-SAM compliance. It has to be a mechanism that's easy for someone to find, easy for someone to use, and you're not taking in any more personal information than is required other than their email address so that you have the internal records that someone opted out. Then, when you get that opt-out request, this is when the internal processes that you have in place are so important, because it's not enough to have the mechanism to opt out. You actually have to have that mechanism work. And the statute requires you to act fast. The statute requires that within 10 business days of receiving an opt-out request that you honor it. So it's important to perhaps automate internally how you are maintaining the list and updating it so that you can be sure that you're within that required time frame. You can't charge a fee for someone to opt out of communications, and as I said, it has to be clear. So best practice is making sure you're honoring those requests promptly, and that might be through some sort of automation. But then building internal processes to verify that that opt-out process works, making sure that you're testing out in your emails that when someone scrolls to the bottom, they actually can click a link or access an email where they can submit to you their request to opt out, and making sure that it works on every email. Testing is an important aspect before you hit send. And finally, monitoring the opt-out process has worked is an important aspect as well. So internalizing the process of making sure you process opt-outs correctly is a key component of CAN-SAM compliance, and a lot of back-end work that should be thought through. So the final thing to keep in mind about CAN-SAM is third-party marketing involvement, because you might engage with partners who help you send email communications, or you might be working in a joint venture type relationship where there are multiple companies involved. It's important that you're monitoring what your vendors are doing about you, or what your business partners are doing when they email your consumers, because under the CAN-SAM Act, everyone in the chain has responsibility for making sure that you're following the requirements. So making sure that whatever internal processes you have in place, the vendor also follows. So maybe it's making sure that the vendor is passing you the opt-out requests promptly so that you can track that internally. So if the vendor in this one situation got a request, you could, across the board, know to take someone off the list. Scrubbing, if you buy a marketing list from a third party to be able to reach out to new customers, it's important to scrub that list to make sure that the people on that list have not previously told you that they didn't want to be emailed with marketing communications. Because once someone opts out, until they give you basically their consent to get added back on your marketing list, it would be a violation to then go later on and to communicate with them. So your third parties can trip you up in marketing. It's not, in addition to you just as a company knowing what to do to comply with CAN-SAM, it's important to be thinking through all the third parties who might impact you. Another popular feature is forward to a friend messages. So that might be something that's enabled by a third party as well. And all those communications, be thinking through who is responsible, who is doing what internal processes to make sure that everything is coordinated, and that way you don't get tripped up from the requirements. So with that, that's at a high level what it was required to comply with the Consent Act. As I mentioned, it is an opt-out process. So you can email as long as you follow the requirements, have that opt-out mechanism in place until someone tells you not to email, that they don't want that spam anymore. But in the next segment, you'll see that the rules are a little bit different when it comes to texting and making phone calls.
Hi, everyone. My name's Sarah Zielinski. I'm a partner in the Chicago office of McGuireWoods. And as Emily said, next we are going to focus on the Telephone Consumer Protection Act, or TCPA. Today we're going to be talking about two important aspects of the TCPA. First, we're going to talk about its provisions governing automated calls and text messages. And then we're going to talk about provisions that are specific to marketing calls. And my colleague Amy Gilbert will cover that. So we're going to start by talking about what the TCPA covers, so that you can issue spot these things in your day-to-day job. Not surprisingly, as the name suggests, the TCPA does cover all types of telephone calls. So that would include certain types of live voice calls, calls placed by an automatic telephone dialing system, and we'll talk a little bit later about what that means, artificial voice calls, pre-recorded message calls. But beyond calls, it importantly covers text messages. And in fact, every time the TCPA mentions telephone calls, you should interpret that to mean text messages. And you will see that the statute doesn't mention text messages. It's been around since the early 90s, before text messages existed. So the statute's just been interpreted over time to reach text messages as well. And we won't spend a lot of time talking about this today, but it also does cover fax advertising. And I know a lot of modern day marketing campaigns don't involve a lot of advertisements by fax. So just be aware that that's out there, but we won't delve into it today. One thing that is a sort of a misconception about the TCPA is that it only covers marketing calls, and that's not true. It covers both marketing and non-marketing calls and text messages, similar to CAN-SPAM. Although, as we'll talk about in a moment, the rules are different depending on what type of call or text message is involved. And finally, you should be aware that it's not the TCPA alone that regulates calls and text messages. There's an entire regulatory scheme. The Federal Communications Commission, or the FCC, has regulations that it implements. It regularly issues rulings interpreting the TCPA. Courts are always interpreting the TCPA. The FTC, Federal Trade Commission, also implements a very similar statute called the Telemarketing Sales Rule. So that's all a long way of saying that if you're trying to develop your TCPA compliance program or try to determine if a certain marketing campaign complies with the TCPA, it's not enough to just read the statute or to Google it. You really are going to need to talk to someone who has experience in the statute to help guide you through all of its ins and outs. All right, so in case there are any questions whatsoever about whether the TCPA should be taken seriously, I wanted to share with you some pretty astounding numbers that should answer that question. Unlike CAN-SPAM, the primary vehicle that we see for enforcing the TCPA is private litigation. So the TCPA has a private right of action, which means that any person who thinks that the statute has been violated can file a lawsuit to enforce it. And if they prove that violation, that person's entitled to collect $500 to $1,500 per call or text message. And in the case of a class action where the plaintiff would be representing other similarly situated people who received the same calls or text messages, you can imagine that those numbers add up really quickly. Unlike other consumer protection statutes, there's no cap on damages, so the numbers can keep going up and up and up. So you see on the slide a couple examples of huge verdicts in the hundreds of millions of dollars. Even if you settle the case early before the case goes to a jury, it's not uncommon for those cases to settle in the millions or tens of millions of dollars. And the one that holds the record right now is a $76 million settlement. And of course, the FCC and FTC are also enforcing the TCPA and the regulations and similar statutes. And so I've included here a couple recent press releases. The FCC recently proposed a $225 million fine for telemarketing violations, which was the FCC's record to date. And then the FTC recently went to court to ban someone from the entire telemarketing industry because of some violations. So regulators are taking this very seriously. anonymously. And in fact, I often hear regulators say that unwanted calls is generally the #1 complaint that their offices receive. Okay, so now let's talk about the nitty-gritty, what the TCPA actually requires. Now, we're not going to have time today to get into all of the ins and outs of the TCPA and its regulations, so we're really going to focus on the two most important and the ones that are probably most relevant to your business. So the most often litigated provision of the TCPA is the one that I have on the slide here, which says that it's unlawful to make calls or text messages to a cell phone using an automatic telephone dialing system or artificial or pre-recorded voice, unless the call is for an emergency purpose or made with prior express consent. So obviously there's a lot to unpack there. We're going to talk specifically about consent and the automatic telephone dialing system. I will say quickly that very few calls fall into the emergency purposes exception, so it's unlikely that you'll be able to rely on that to comply with the TCPA. All right, so getting consent is the most straightforward way to comply with the TCPA. Consent is, as it sounds, it's the person's permission to call them or text them. So what does that look like, and how do you get consent? Well, the answer is that it depends on the type of call. And this is where we're going to see some similarities with CAN-SPAM, although I don't think that the statutes don't define the distinctions the same, so there are differences. But it depends on whether the call is a telemarketing call or a non-telemarketing call. And how do you tell the difference? A telemarketing call is any call that encourages a purchase or advertises the quality or characteristics of a product or a service. And on the other hand, a non-telemarketing call is more account related. So it could be confirming a transaction or a delivery notification. And if the call or text messages has a dual purpose, meaning it's both a mix of telemarketing and non-telemarketing, then it's treated as a telemarketing call, and you have to comply with the telemarketing portions of the statute. So an example of this might be if a customer has reward points that can be redeemed and they're about to expire. Perhaps you want to send them a message informing them, hey, these are about to expire. Well, courts have considered a situation similar to that and said, well, one purpose of that might have been to inform the consumer, but another purpose was to encourage them to come into the store, make a purchase. So we're going to treat that dual purpose call as a telemarketing call. So if the call is a telemarketing call, how do you get consent? Well, the term of art in the statute is that you need to get prior express written consent. And this has very specific requirements. So the consumer has to provide a signed writing. So they actually have to have a signature, although e-signatures, like clicking a box, can satisfy that signature requirement. And it has to clearly authorize the seller to deliver messages using an automatic telephone dialing system. And as a best practice, this consent should also identify the phone number where the consumer is providing consent and say to whom the consent is being provided. And it also is required to disclose that consent is not a condition of purchase. So in other words, the consumer can't be required to give consent in order to make a purchase or to use your services. Now, if it's a non-telemarketing call, it's actually a lot easier to get consent. Simply providing a phone number can be sufficient to establish that the person has provided consent to be contacted. The important thing to remember here, though, is that all messages have to be within the scope of the consent given, and scope means the messages must be closely related to the purpose for which the telephone number was provided. So in some cases, the purpose might not be stated, and so that's much broader consent than, for example, a situation where you tell the consumer that you need their phone number in order to verify their account. And in that case, if you tell them that, then they've only given you consent for that purpose. And so you can sometimes narrow consent maybe beyond what you're intending. So you have to be careful about the language that surrounds getting the consumer's phone number. In most situations, consent can be revoked. So this means if someone says, stop calling me or stop sending me text messages, you no longer have consent. And that means that you can no longer contact them using an automatic telephone dialing system on their cell phone. All right, so the last point I'm going to make before turning it over to Amy is the question of what is an automatic telephone dialing system. So this is a second way to comply with the TCPA, as I'd mentioned. Instead of having the person's consent, you can just choose not to call them using an ATDS. And so that begs the question, what is an ATDS? Well, that's actually a really tough question to answer because the definition has been in flux for years. Just as soon as we think we've gotten some clarity, the definition or the interpretation of it changes all over again. So it's been continuously changing. Now, the Supreme Court has just agreed to take up this issue and will likely be resolving certain aspects of the definition in 2021. So it's possible we'll have some clarity then. But until that time, it is best to consult with a TCPA attorney anytime you're considering placing calls or text messages using automated technology so that they can assess whether it qualifies as an ATDS. So with that, I'm going to turn it over to Amy to talk more about the TCPA's marketing restrictions.
Thank you, Sarah. My name is Amy Gilbert, and I'm an associate in the Chicago office of McGuireWoods. In addition to the TCPA restrictions Sarah discussed that relate to the technology used to send telemarketing messages, there are other components of the TCPA that apply to marketing calls regardless of the technology used. First, the TCPA prohibits telephone solicitations to recipients on the National Do Not Call list. The National Do Not Call list applies to consumers. It does not apply to businesses. Telephone solicitations is a defined term, and it has the same definition as telemarketing. So as Sarah explained, any call that encourages the purchase of a good or service will constitute a telephone solicitation. However, unlike the TCPA provisions concerning the technology used, there are 3 exceptions that apply to telemarketing calls to consumers on the Do Not Call list. The prohibition on telemarketing calls to consumers on the Do Not Call list do not include calls made to any person who provided their prior express invitation or permission to receive that call or text message, any person with an established business relationship, or any call or text message that's sent by or on behalf of a tax-exempt nonprofit. Regarding that second exception, an established business relationship is a defined term that just means that there's a prior relationship between the consumer and the company that's either based on a prior purchase or transaction within the last 18 months preceding the call, or the call recipient inquired about the product or services within 3 months preceding the call. Also of note is that there will be no liability for a company who makes a telephone solicitation to a consumer on the National Do Not Call list if a company can demonstrate that the violation was made in error and that as part of its regular business practices, it meets the following standards. First, the company will have to show that it's established and implemented written procedures that comply with the National Do Not Call rules. The company will also have to show that it's trained its personnel in the Do Not Call procedures. The company will also show that it's maintained and recorded a list of telephone numbers that the seller may not contact based on those consumers that are on the Do Not Call list. And the company must scrub its call recipient list against the National Do Not Call list to prevent these telephone solicitations, and then it must maintain a record that it's done so. This is another instance where internal business procedures are critically important to be compliant with the TCPA. Second, under the TCPA, a company cannot make telemarketing calls unless it itself has established a company-specific Do Not Call list. This means that in addition to not making telemarketing calls to consumers who are on the National Do Not Call list, a company must also have procedures in place for maintaining a list of people who request not to receive telemarketing calls from that specific company. Those procedures must meet the following minimum standards to be compliant under the TCPA. The company must have a written policy for maintaining a company-specific Do Not Call list, and this policy must be available on demand if requested. All personnel engaged in marketing must also be informed and trained in the existence and use of the company-specific Do Not Call list. The company must also record all Do Not Call requests and place the recipient's name and phone number on the list at the time the request is made. The company must also maintain a list of all of these do not call requests and honor those requests for 5 years. And they also must do their part to honor those do not call requests within a reasonable period of time, not to exceed 30 days. It's critical to note that if a customer requests not to receive telemarketing calls from that specific company, that request will terminate any established business relationship for the purpose of telemarketing, even if that caller continues to do business with the company. In addition to complying with the TCPA's requirements, the Federal Trade Commission, or FTC, has also implemented the Telemarketing Sales Rule, or TSR, and that has specific requirements regarding telemarketing as well. Any business engaged in telemarketing must also comply with the TSR, but in many respects, the TSR tracks the requirements of the TCPA. So, for example, some of the TSR's requirements that you'll also find in the TCPA include the fact that calls may be placed only between the hours of 8 a.m. and 9 p.m. based on the local time of the person being called. Also, that calls and text messages must identify that the message is from or on behalf of a specific company. And finally, that the caller identification number that pops up when the company calls must be a number that can be called during regular business hours in order to make a do not call request. The TSR also sets requirements for artificial and pre-recorded voice messaging calls. And for those type of calls, a company must adhere to another set of requirements. The company must provide the registered business name of that company. It must provide an automated opt-out mechanism for the consumer to make do not call requests, including an explanation of how to use that mechanism. This opt-out mechanism can be an interactive voice or key press activated mechanism. If the consumer does elect to opt out, the company must automatically record the consumer's number to the company-specific do not call list and end the call immediately. The company must also, during or after the message, state the telephone number for the company, and that telephone number must be toll-free. And finally, for answering machine or voicemail messages from the company has to provide a toll-free number that allows consumers to call back and connect directly to the opt-out mechanism and automatically record the consumer's number to the company-specific do not call list. Admittedly, there are a lot of nuts and bolts to the TCPA and to the TSR, but hopefully this brief overview provides guidance as to how to stay compliant. Certainly, working with legal counsel will assist in navigating these complex statutes. Thank you so much for joining us today. That concludes our program. We have one more episode in this series, and you can find the rest of our episodes on McGuireWoods' website. Thanks so much for joining us.